Everyone. In our today's class, we will study exceptions of banker's lien. Okay, so in a previous video, we have studied the meaning of lien, kinds of lien, and also the circumstances under which a banker can exercise his right of lien. Okay, so the banker has the right of general lien. So, what is general lien? So, it is the right of a creditor to retain any property till the general balance is repaid. Okay, so in the case of your general lien, the banker can sell the property in case of default payment. Okay, so today we will see what are the circumstances or under which cases the lien is not available to the banker. Okay, so the first one is safe custody deposits. Here the banker cannot exercise his lien in respect of securities deposited for safe custody. Okay, now suppose if the customer has kept some valuables in the safe locker, at that time the banker cannot exercise his lien on that particular property, which is property or documents or anything that is in the locker. Okay, second one, trust funds. So here the banker cannot exercise his lien on trust account for payment of private loan. Okay, I had given you the example for the relationship between banker and customer as trustee and beneficiary. Okay, that is, I had given the example of father and son. Now suppose if the now suppose if we consider the same example, suppose if the father has taken some private loan, at that time the banker cannot exercise the right of lien on the trust funds. Okay, that means the banker was acting as a trustee and as a beneficiary relationship, that is, the father had kept some amount for the purpose of the son's education, so the banker cannot exercise the lien on that fund which was kept for son's education. That is because the banker is acting as a trustee over there. Okay, that's why the banker cannot exercise the lien on the trust funds. Okay, so trust funds maybe any kind of funds, maybe the will or any document under which the banker is acting as a trustee. Okay, so under the trust funds the banker cannot exercise his right of lien. Then securities left with banker negligently or by mistake. So now suppose the customer has taken the loan from the bank and he did not pay the loan. Okay, that is, even after the due date he did not pay the loan. Now suppose one day the customer visited the bank and he left something by mistake, maybe some important document, maybe some cash, or maybe mobile phone or anything. At that time the banker cannot seize that particular asset, he cannot keep that cash for himself against the loan which has been taken by the customer. Okay, so because the customer has left that thing by mistake over there. Okay, on such cases the banker cannot exercise his right of lien. Then when bill or money or securities are deposited with the banker for a specific purpose, lien cannot be exercised. Okay, now the customer has deposited certain money and has told the banker that it is for some specific purpose. Okay, at that time also the banker cannot exercise his right of lien. Okay, now suppose if the customer has said this is for bill payment or maybe some other purpose, at that time the banker cannot take that money against the loan which is taken by the customer, that is the loan which is due by the customer. The next one is your contingent debts. Contingent debts are nothing but your future debts. So here banker cannot exercise his right of lien on future debts, that is debts not due. Okay, suppose if the customer has taken the loan for 5 years. Okay, now for the due date for that loan is 5 years. So before 5 years or maybe in the third year or in the second year, the banker cannot sell the property which is belonging to the customer. Okay, so after 5 years he can exercise his right of lien, but not before that. Okay, that is on not on future debts but only on the debts that are due. Okay, next one, accounts are in different capacity. So here no lien is available to the banker if the accounts are in different capacity. Okay, for example, partnership account against private account of the partners. Now suppose if there are three partners in a partnership firm. Okay, as we know, the customer of bank is not only a individual, it might be a individual, it might be a joint stock company, it might be a partnership firm, or it might be any other society as well. Okay, now suppose there is a partnership account, say in bank ABC. Okay, now three partners are there. One partner has taken private loan, that is his personal loan, he is having his personal account in the same bank. At that time the banker cannot take the money from the firm's account and settle it against the private account of the partner. No, okay. Nor he can take funds from the partner's account and adjust your, no, okay. So whatever the whose account is there, okay, the customer's account is to be deducted, okay, not some other account. So here accounts of different capacity, on such accounts the banker cannot exercise his right of lien, okay. So that is about the banker's right of lien. So next comes your banker's right of set off. This is very important from the point of view of your examination. Usually they ask it for 5 marks, okay. So this is also simple. Let's see what it is. So mutual claim of debtor and creditor are adjusted, and only the balance of amount is payable by the debtor, okay. So what is this? It is a legal right which helps the banker to combine two accounts. So this is also called as your right of combining the accounts, okay. So it is the legal right, that is it is statutory right given to the banker to combine the account which is in the name of the customer, and to adjust debit balance in the account with credit balance in the another account, okay. Now suppose if the customer is having two accounts, okay, suppose this person is the customer of your bank, okay. He is having two accounts in your bank. One is your SB account, another one is your OD account. OD means what? Overdraft account, okay. So now his SB account is having a credit of rupees 5000, and his OD account is having a debit of rupees 5000, okay. So now the due date is over, okay. Due date means what? On the date which the customer had to repay, okay. So now the balance in the OD has become due, and here on the due date the customer has not made any payment, okay. So after becoming due, this debit balance, okay, so what happens? It becomes overdue. So after overdue, what will you do? As a banker, you will send a notice to the customer, okay, that your OD account balance of rupees 5000 has become overdue. Now if the customer did not give any response for your notice, that is he did not make any payment for your notice, even after receiving the notice he did not make any payment, okay, at that time what you will do? You will transfer rupees 5000 from his savings account to the OD account, okay. So here you have debited the entry of rupees 5000, and in OD account you made a credit of rupees 5000, okay. So here now what will be the balance in your savings account? It will, in the customer's account it will be 0. In the OD account also the balance will be 0, because you have cleared the OD balance, that is debit balance of rupees 5000, okay. So whatever you have transferred from SB account to OD account, here you have combined two accounts of the customer itself. So this is your right of set off, okay. So here you are combining two accounts and you are making the claim over here, that is you are setting off the whatever the outstanding debt is there, you are clearing it off, okay. So next, objectives, okay. Why is set off done? To reduce the net amount due to the banker from the customer, okay. So here the risk is also less for the banker, because if the customer is having two accounts, it is easy for the banker to recover the loans which is taken by the customer, okay. Second one, ensure the safety of funds, okay. I hope this thing is clear to you all. Set off, okay, it is nothing but, suppose if you people have to give me 3000, okay, and I have to give you 2000. So what I will say, you don't give me 3000, you just pay me 1000, okay. So that is what set off, okay. Even you have to give me, even I have to give you. So here you are making, both of us are making a mutual agreement that you just give me 1000 and a debt is cleared, okay. So that is set off, or combining of the accounts by the banker. So next comes conditions to exercise the right of set off. So here first one, debts due. So the banker can exercise this right to set off on debts which become due and not in respect of future debt, okay. That is, suppose if the debts are for future, okay, for the future period, at that time you cannot go for set off, okay. Now the customer's SB account is having rupees 10,000, okay, and the debts due is 5000, or he is having a OD account or the loan account 5000, which is for a period of 1 year. Okay, after 1 year it will become overdue. So you cannot say that yes, the customer's SB account is having 10,000 now only I am going to set off 5,000. You cannot do that. Okay, whenever the debt becomes overdue or the loan becomes overdue, that is after a period of 1 year or 2 year, at that time you can go for this set off. Okay, at that time, suppose if the SB account is having 10,000, you can take 5,000 and adjust it with the loan account and close the loan account. Okay, so that is what debts due. Okay, not for the future debt. Next, debts must be certain. Okay, what is this certain? Whatever the debt is, that it should be clear. Okay, that is, you cannot say debt about rupees 20,000. What is this about? No, exactly you have to state in 10 figures what is the amount of your debt. 20,300 rupees, exactly whatever the figure is there, it must be certain. Okay, next, accounts in same name and same capacity. Okay, now suppose if you are dealing with this set off, at that time the customer who is having, okay, the loan account, the same customer must be having savings bank account in your bank. Okay, it must be not that he is a partner of a partnership firm, he is having a SB account over there, and here you are dealing with the partnership account. No. Okay, loan of the partnership account, you cannot deal it like that. Okay, so here if the customer's name is ABC, he must be having a loan account in his name itself, that is ABC's loan account or OD account or cash credit account. So any account, it should be in his name only, in not some other capacity. Okay, next, notice must be given to the customer. Generally the banker should take an agreement. Okay, that is, he must make an agreement with the customer authorizing him to combine the account without notice. In the absence of such agreement, a reasonable notice must be given to the customer. Generally what happens at the beginning only, okay, if the customer is having the SB account also and some other account in the same bank, at that time the banker will make a agreement saying that in case of your default means what, in case if you don't make any payment, at that time I am going to combine your accounts and adjust the balances. That is, whatever is in your SB account, I am going to take it and set off the loan. Okay, he can say it like that. So it is understood, it is a written agreement. In case if such agreement was not made between the banker and the customer, what the banker has to do, when the loan amount is overdue, or once when the date is over, due date is over, he has to send the notice to the banker, no, sorry, customer. Okay, saying that your account is due, that is your loan account is due, you must make the payment, or else I'm going for set off with so and so account which you have in our bank. Okay, so that is what notice must be given to the customer. Then there should not be expressed agreement to the contrary. Okay, so contrary means what, suppose now you have sent the notice and the customer has said no, you don't go for set off because that particular money I have reserved for so and so thing. At that time you cannot go for this right of set off. Okay, now the question arises, the customer is having FD account with the bank. Okay, he is having a SBA FD, he has kept FD of rupees 25,000 and he has a loan of rupees 20,000. Okay, so after the maturity of that FD, the customer will be receiving say 26,000. Okay, so now what you can, now your 20,000 loan whatever is there, it has become due. So now this FD has not matured yet, at that time you cannot exercise your right of set off. Okay, so once when the mature FD has matured, only after that you will go for set off. Okay, so once the suppose here your loan has matured, the FD will be due after 3 months. Okay, so after 3 months if the FD is due, you will go for set off after 3 months and not now only. Okay, I hope you are getting these things. Okay, so next one, in case a banker receives garnish order. Okay, garnish order we are going to study next. Okay, so what is this, this we will study in detail in a next class. Okay, so in this, whenever the banker receives garnish order, he has to freeze the customer's account. Okay, so here what happens, in respect of funds belonging to his customer, he has to first exercise his right of set off and thereafter surrenders only the remainder amount to the judgment creditor. Okay, this will study in detail in the next class. I will explain this. Okay, so what happens when garnishee order is received by the banker, so there we will discuss this point. Okay, next comes your automatic write off set off. Okay, what is this automatic? Generally the banker has to give the notice to the customer. Okay, so sometimes it is automatic, that is he need not give the notice to the customer. Okay, he will go for a direct set off when, so first one, death, insanity, insolvency of the customer. So whenever the banker comes to know that the customer has died, he has taken the loan and he has expired, so what he will do, whatever the amount is there in his SB account or some other, maybe FD and all, what he will do, he will consider it as the clearance of loan, or he will consider that amount for set off, and whatever is remaining he will give to the nominee. Okay, next, on the insolvency of a partner or unwinding of a company, all of us know that suppose if any partner goes insolvent in the partnership firm, okay, at that time what they have to do, they have to open another account. So at that time, whatever the account amount is there in the balance in the account of the partners, he is going to set it off. Okay, now suppose for example there is a customer called as ABC. Okay, so ABC has 20,000 in his SB account. Okay, SB account is having how much? He is having 20,000 in his SB account, and he has a loan account, say rupees 15,000. Okay, now on his expiry, the banker comes to know that ABC has expired. So what he will do, he will set off this loan amount of rupees 15,000 and give 5,000 to the nominee of ABC. Getting the point? Okay, so that is what set off. Then again, on the receipt of garnishee order, the banker goes for automatic set off. Then the banker has the right to set off customers credit balance held at different branches of the same bank. Okay, now there are various branches of the bank. Okay, say you are having one account in SBI, which is in Ashwini Circle. You have another account, loan account in SBI, which is in Banwasi Road. Okay, so your various branches are there. So here the banker can make the set off against the accounts held at the different branches of the same bank. Okay, suppose if you are having savings account in your Ashwini Circle and you have a loan account in Banwasi Road, the banker can set off. Okay, so whatever savings balance is there in your Ashwini Circle, he can set it off with the loan account which is in the SBI, which is in Banwasi Road. Okay, so that is what automatic set off. Okay, so that's it for the day. If you are not understanding, you can ping me. Okay, so thank you, have a nice day.